Further hearing in the appeal, Secretary of State for Work and Pensions against Gubeladze.
Yes, Mr. Manfield.
Can I make one addendum before I start to my Article 14 argument, the argument on the European...
Yes, of course you may.
No,
Yes. I'm
human
just
rights.
making sure I've got enough notebook.
Yes. Yesterday I I explained that the comparators for the purposes of Article 14 for an accession state worker who would not be eligible for state pension credit because of a failure to sign the register for work between 2009 and 2011 was another EU national who was not required to sign the register as a condition of that work counting towards state pension credit. I'm grateful to Mr. Delamere, who has pointed out another comparator, potential comparator for the A8 worker in that Article 14 comparison, who would be an A8 national who worked as a self-employed person in the United Kingdom between 2009 and 2011. And the discrimination between those two groups of persons would also require, just in enjoyment of the Article 1, Protocol 1 right under Article, in relation to the state pension credit, would also require justification if, as I submit, this is within the ambit of an Article 14 analysis. I left my submissions yesterday having said what in our on our case was wrong with the Secretary of State's argument, which had been abandoned in the Court of Appeal, but resuscitated in front of this court, that the extension decision in 2009 was not susceptible to proportionality analysis. And I showed you why Ponomaryov, particular paragraphs 50 to 60, at MS 2071 to 2072, supported the submission in relation to the Human Rights Act. So the real question in my submission is not whether a proportionality analysis is engaged at all, plainly it is, but whether Upper Tribunal Judge Ward erred in his approach to that analysis. And that analysis is at paragraphs 104 to 118 of the Upper Tribunal's judgment, for your note, MS 270 to 274. The reason that is the analysis where an error of law has to be found if Mr. Chamberlain is to succeed is because the Upper Tribunal is an expert tribunal, and it appears to be common ground that the Court of Appeal, and indeed this court, should only interfere with that decision if they can discern an error of approach, not whether they would have conducted the balance in a different way, but whether there's an error of approach in the way that Upper Tribunal Judge Ward did it. I don't think I need to turn it up, although I will if you want me to, but the authority for that proposition is Aubrey, decision of the Court of Appeal.
I'm sorry, I didn't hear.
Aubrey. It's bundle 2.4 of the authorities, tab 68, paragraphs 14 to 18, MS 2419 to 2420.
I'm sorry, paragraphs?
It's paragraphs 14 to 18.
Thank you very much.
And it's an authority actually often cited against claimants in these cases seeking to displace decisions on appeal, to say, well, the Upper Tribunal made that judgment, looked at the proportionality test. You can only displace it if there's some fundamental error of approach.
Thank you.
So Mr. Chairman doesn't quarrel with that principle, but seeks to persuade you that there was an error in the Upper Tribunal's approach. And the first error, which he sought to claim that the Upper Tribunal had made, was that it took the decision on proportionality for itself. I took you to his written case, paragraphs 42.1 and 42.2 on that, MS 135. And I showed you Lumsden, I told you that Lumsden is authority for the proposition that a proportionality question is one for the court, and it must make the decision for itself. It may be that a slightly more nuanced way of putting the case for the Secretary of State is that the reason it was an error of approach or said to be an error of approach for the Upper Tribunal to take that decision was because this was a national measure which implemented an EU directive. The Secretary of State was entitled to a broad margin of policy appreciation, and the Upper Tribunal ignored that margin. That complaint is essentially academic because in paragraph 118 of the Upper Tribunal judgment, MS 273, the Tribunal held that the extension decision would have been disproportionate, even applying the very low standard of scrutiny contended for by the Secretary of State. So even on that low standard of scrutiny, it contended that this was, that the Upper Tribunal's judgment was that this was a disproportionate decision. But I say that the Secretary of State's criticisms of the Upper Tribunal are based on an incomplete citation and an erroneous approach to the leading authority on this issue, which is Lumsden. And I will ask you to turn that up, please. It's in Bundle A13 of the authorities, tab 29, and it starts at 1372. That was the case about whether the quality assurance scheme for criminal advocates was a disproportionate restriction on rights to provide services in the EU. Lord Reid took the opportunity to give a very helpful and lengthy analysis of how proportionality analysis works as a matter of EU law. And if I can take it up at paragraph 20 on MS 1372, that is where the issue in that case is identified. The right to restriction on rights of professionals to practice law was justified by an overriding reason relating to public interest, i.e. the risks posed by poor advocacy. And then paragraph 24 sets out the paragraph 23 identifies just above letter F, MS 1372, that the sort of attempt to categorise different categories of cases and how proportionality applies in different cases risks conveying the impression that the court's approach is less nuanced and fact-sensitive than it actually is. So it's not an error of a law to say you put it in this box, and it's really a this box case. It's not how it works. Paragraph 24 identifies that proportionality is a general principle of EU law. And paragraph 25 then says that it applies to legislative and administrative measures adopted by EU institutions, but also applies to national measures falling within the scope of EU law, which interfere with proven and protected interests. That's the British sugar point. And Mr. Chamberlain does not suggest, as was suggested on behalf of the Secretary of State in Zalewska, this is not within the scope of EU law. He concedes that it is. He says it doesn't interfere with protected interests, and I've made my submissions on why that's wrong yesterday. Then in paragraphs 33 to 34, the Supreme Court, Reid, set out the nature of the proportionality test. And paragraph 33 was cited in the written case for the Secretary of State. Proportionality involves consideration of two questions. First, whether the measure is suitable or appropriate to achieve the objective pursued, and secondly, whether it's necessary to achieve that objective, or whether it could be attained by a less onerous method, and some debate about whether there's a third question, the proportionality stricto sensu question, whether the burden imposed by the measure is disproportionate to the benefit secured. But where that question is argued, the court will consider it. What wasn't cited was, in paragraph 34 says, apart from the questions which need to be addressed, the other critical aspect of the principle of proportionality is the intensity with which it is applied. It's flexible in its application. This is over the page at 1375, letter A. Just above, below letter A, it's important to avoid an excessively schematic approach because the jurisprudence indicates that the principle is flexible in its application. And then this, not in the written case for the Secretary of State, the court's case law applying the principles in one context cannot necessarily be treated as a reliable guide as to how the principle will apply in another context. It is necessary to examine how in practice the court has applied the principle in the particular context in question. And then, with that caveat in mind, paragraph 35, the court looks at three different types of cases: review of EU measures, review of national measures relying on derogations from general EU rights, and the review of national measures implementing EU law. And in my submission, Upper Tribunal Judge Ward was right to say that this was a review of a national measure relying on a derogation from general EU law rights, because there were general EU law rights of freedom of movement, which, using the power conferred on it in paragraph 5 of Annex 8 of the Act of Accession, the Secretary of State chose to derogate from. Then in paragraph 36, the court focuses on the function of proportionality as a ground of judicial review in EU law, concerned with balancing of private interests adversely affected by such measures against the public interests which the measures are intended to promote. Paragraph 36 through to 38 explain how that approach operates. It's been paragraph 37, proportionality as a ground of review has been applied most frequently to measures interfering with fundamental freedoms guaranteed by the EU treaties. The court is concerned first and foremost with the question whether a member state can justify an interference with a freedom guaranteed in the interest of promoting the integration of the internal market and the related social values which lie at the heart of the EU law project. In circumstances of that kind, the principle of proportionality generally functions as a means of preventing disguised discrimination and unnecessary barriers to market integration. Where, this is just above letter G, a national measure does not threaten the integration of the internal market, for example, because the subject matter lies within an area of national rather than EU competence, a less strict approach is generally adopted. And also that's the case in contexts where an unregulated economic activity would be harmful to consumers. So that's the Valesco type example about importing cigarettes. Then paragraph 38, where member states adopt measures implementing EU legislation, they are generally contributing towards integration of the internal market, rather than seeking to limit it in their national interests. In general, therefore, proportionality functions in that context as a conventional public law principle. On the other hand, and I place particular emphasis on this, where member states rely on reservations or derogations in EU law legislation in order to introduce measures restricting fundamental freedoms, proportionality is generally applied more strictly. And there is authority that says that temporary derogations from the free movement rights which are contained in the Act of Accession are to be interpreted strictly using that principle. Can I just give you the references for your note? There's a Commission decision, re Spain, which is A2 for 75, paragraph 17, MS 2638, and then to like effect in the context of the Greek accession, Peskaloglu, which is 1A1 to 19, paragraph 12, MS 1058.
Can you help me? I mean, I've been reading this passage and sort of puzzling over it. If we go back to paragraph 33, I mean, they say that one's obviously everything depends on the context. Of course, that's not very helpful unless one knows what to do with it. But surely a lot depends on what the objective is. I mean, here one can look at it in a number of different ways, but on one view, what we're dealing with here is a regulation which has been brought in some time ago, and now we're considering whether to extend it in a situation where we have a general disturbance in the employment market. And what I think the Secretary of State is saying, well, the objective is not particularly dramatic, it's simply to avoid making things worse. And we've got the advice from a committee which says that this will help in a small way to avoid making things worse. And if that's the objective, then you say, well, is this a sensible way of achieving that objective? Yes. Is it necessary? Yes. I mean, we could do a lot more.
Where is it necessary come from?
Well, but that's what it said here, 33.
Yes,
you know,
but
I mean,
you
we've
say,
got,
is it
we've got
necessary? Yes. The Secretary of State nowhere says it's necessary. They asked the Migration Advisory Committee, is it sensible?
Yes.
And they say yes. Nowhere do they look at...
But is that the point? Because if one's looking at the narrow issue, then it comes down to a very close debate about whether what is meant by sensible, whether that encompasses proportionality. But he then go on to talk about the third question, stricto sensu, which seems to be a much broader question about whether you look at the thing in relation to the benefits secured as compared to the disbenefits. Now that seems to me, if you take that view, then clearly Judge Ward is doing just that. He's looking in the broader context. But Lord Reid and Lord Toulson seem to be saying, well, there's some debate about whether there is such a third question. So it seems to me it's rather important to know whether there is or there isn't.
Well, there is, my lord. I think there is where it's argued, as in Fidesa. We've also cited, there's an extract from Craig and de Burke, which I'm sure Mr Royston will give me the reference to, that says the same thing. But Lord Reid says, in practice, where the court has often included the stricto sensu point in the formulation and addressed it separately, and gives the formulation in Fidesa. But if I can just, I'll come back to this point, but if I can just finish the analysis of how the proportionality exercise is applied, the important point in paragraph 38 is that, yes, the Secretary of State was looking at whether to prevent disruption of the labour market, but he was doing so in a paragraph 38 context, the bottom of MS 1375, relying on a derogation in EU legislation, that's the paragraph 5 power, to introduce measures which restrict fundamental freedoms which would otherwise exist. Because that's what Lord Justice Elias said in the Miscovich case, that these are freedoms that would exist, but for the power of derogation which has been exercised. Now, yes, the reference to Craig and de Burke is volume 2.4 of the authorities, tab 76, MS 2641. But if I can just complete the review of the way Lord Reid looked at the matter. In paragraph 40, he then looked at where EU legislative or administrative institutions exercise a discretion involving political, economic or social choices, especially where a complex assessment is required. And in those circumstances, the court will usually intervene only where it considers the measure is manifestly inappropriate, that's manifestly inappropriate, having regard to the objective which the competent institution is seeking to achieve. Paragraph 44, Lord Reid makes the point in this EU law context, which my Lady Baroness Hale made in the context of the Humphreys case in Article 14, that even if one is applying a manifestly inappropriate test, that doesn't mean that the court's scrutiny of the justification for the evaluation is cursory or perfunctory. The court will be slow to substitute its own evaluative judgment, won't intervene just because it would have struck some different balance between countervailing considerations, but it will consider in some depth the factual foundation and reasoning underlying the judgment. So that gives the court authority without, even on a manifestly inappropriate test, to look at what analysis there was and to look at whether the relevant questions for the proportionality exercise have been asked and properly analysed by the decision maker while not substituting their own judgment. In paragraph 50, MS 1379, Lord Reid turns to how those principles, looking at the way the European Court would analyse the proportionality of measures taken by EU institutions, apply to measures adopted by member states within the sphere of application of EU law. And paragraph just above letter E, compliance with the principle of proportionality is also a requirement of the justification of other national measures falling within the scope of EU law, including those which derogate from other rights protected by the treaties, such as the rights to equal treatment or non-discrimination, or other fundamental rights such as family and life. Then paragraph 56, looking at, the court says, just above letter G, paragraph 56, I'll start at the beginning. The justification for the restriction tends to be examined in detail, although much may depend on the nature of the justification and the extent to which it requires evidence to support it. For example, justifications based on moral or political considerations may not be capable of being established by evidence. Well, that's not this case. The question is this going to help with disruption of the labour market?
Well, sorry, just on that, it is. Not very much, but it is. This measure is going to help with the disruption of the labour market. Yes. Not very much. I mean, I think it goes back to what my Lord Culmouth was asking you about the relationship between the first and second stages of proportionality analysis and the third, the stricto sensu approach. Yes. I mean, was the Secretary of State not entitled to say, well, if I want this admittedly small benefit to the labour market to be achieved, then it is necessary to have this measure.
He is entitled to do that if he balances it and considers the problematic consequences to those affected, which he doesn't do. I'm looking at the degree of scrutiny at the moment which the court would give. Mr. Chamberlain says this is really the sort of high politics that the court should take a very hands-off approach, and I'm saying that it's closer to a technical. This is the next sentence in Lord Reid's speech at letter G. Sorry, it's not. It's the sentence after the next sentence. The next sentence is that the same may be true of justifications based on intuitive common sense.
Sorry, which paragraph are you reading from?
This is paragraph 56, and it's just
Oh, yes,
by
it's just above G, yes. Sir.
Yes, and then just by letter G, an economic or social justification, on the other hand, may well be expected to be supported by evidence. And, my Lord, I take the point that there is some evidence in the MAC report, but it's fairly tenuous evidence, and it means that it doesn't take much consideration to counterbalance it. There isn't evidence of that consideration, which is why I say there's no error of approach in the way that the tribunal looked at it.
Yes, well, the upper tribunal focused on the third stage, the stricto sensu balancing exercise.
Yes, but
there was no error, you say, before they got there.
Well, I say that that's because they haven't. The reason he says even on the manifestly inappropriate test, there isn't a consideration of whether it's potentially. I mean, I'm not going to repeat what the analysis of the MAT report, but it's really very tenuous evidence, and there's no attempt at all to balance that against the detriment that this causes to accession state nationals who are workers rather than self-employed people, or in comparison with others, or the damage to the integration of the market, which is caused by continuing this measure on an exceptional basis.
Right, but I mean, isn't that something that has to come in at the stricto sensu stage?
Yeah.
Yes.
Yeah.
Yes.
Only at the stricto sensu stage?
Well, at the... He's entitled to say there's been no consideration by the Secretary of State of the effect of this on fundamental rights and market integration at all. He's looked at, is it sensible in terms of keeping some people out of the labour market? He hasn't said, but what is the balance? There is no evidence from the Secretary of State, no witness statement.
Well, that's why I ask, is it only a consideration at the stricto sensu stage?
No, my
because
Lord,
it seems to be the last stop in the analysis.
Yeah, no, my Lord, it isn't. Is there a detriment? Is there a detriment to a protected interest stage? And there is a detriment to a protected interest. I don't get here if there isn't a detriment to a protected interest, because the proportionality in EU law is a question of detriment to a protected interest.
Well, I struggle with that, because if you're talking about the three stages that Lord Reid sets out and Lord Toulson set out in paragraph 33, I mean, the first question is the measure suitable to achieve the objective? It may be a modest objective, but the answer may be yes. The second stage is whether the measure is necessary to achieve that objective, or could be obtained by a less onerous method. None of that involves balancing. I mean, all this stuff seems to come into the third stricto sensu stage. But your argument, as I understand it, and I understand it, I think, is that in paragraphs 114 to 118, there was an unobjectionable assessment of the stricto sensu stage.
Yes. Yes, I mean, I do say that the necessity stage involves saying, is this an important enough benefit and interest to justify the interference with restricted interests? I suppose that either comes into the necessity stage, about whether the objective is sufficiently important to justify this very serious effect on other people, or you can say it's part of the stricto sensu stage. But it is a well-established point in EU law that stricto sensu analysis can take place. If you were minded if it was decisive this case, that would be a point that would need referring. But it isn't in my submission. There's clear EU authority on that. We do say that the measure in this case fails the necessity test because there are other things which could have been done to prevent people if there were sectors of the market where one was trying to stop people
Sorry,
participating in
forgive
the
me,
market,
I thought there was nothing else that could be done. I mean, that goes back to what you're entitled to maintain as your measure under Annex 8. I thought you were stuck with...
Well, this would be deciding not to maintain your measure under paragraph 5 and instead to use your power under paragraph 7 to say we need work permits for certain sectors. We won't have the accidental burden. I'm quite anxious to get through my analysis of the Lumsden case, and then I can deal with the application of it. Because paragraph 44 was saying even if it's a manifestly inappropriate test, the court will consider the analysis, the factual foundation and reasoning in some depth. The paragraph 50 then applies this to national law, and paragraph 56 is important, as I was saying, an economic or social justification, which is what one has here, may well be expected to be supported by evidence. And then paragraph 60, particularly in situations where a measure is introduced on a precautionary basis with correspondingly less by way of an evidential base to support the particular restrictions imposed, it may well be relevant to its proportionality to consider whether it is subject to review in the light of experience. Well, here we have a measure where we have experience of knowing that it's not intended to restrict numbers, and it hasn't really been relevant to that. And so that is part of the question of necessity in this case.
But the MAC said, yes, it does restrict numbers. Not a lot, but it does.
Or it may do.
It may do. It's precautionary. It was talking about what might happen in future.
Right.
I think no evidence from the previous monitoring to suggest that it did, that it was likely that it might. Paragraph 73 was cited by the Secretary of State just below letter H. It says, or just above letter H, when assessing the proportionality of EU measures, to the extent that the directive requires the national authority to exercise a discretion involving political, economic or social choices, especially where a complex assessment is required, the court will generally be slow to interfere with that evaluation. In applying the proportionality test in circumstances of that nature, the court has applied a manifestly disproportionate test, but the court may nevertheless examine the underlying facts and reasoning, so what was said in paragraph 50, carried over. And then this, again not cited in the Secretary of State's case, where, on the other hand, the member state relies on a reservation or derogation in a directive in order to introduce a measure which is restrictive of one of the fundamental freedoms guaranteed by the treaty, the measure is likely to be scrutinised in the same way as other national measures which are restrictive of those freedoms. How is that? Back to paragraph 56, it is with expecting evidence of the economic and social benefits and assessing the strength of that. There is then an analysis of the different ways in which the courts in England and Wales and Scotland addressed the question of EU measures implementing EU law in the Sinclair-Collis case. And in paragraph 82, the reasoning in that case which was looking at the manifestly inappropriate test, the reasoning of the English Court of Appeal was rejected. So in a derogation case of this, I'm not taking you very closely to the Sinclair-Collis analysis. The problem with the Sinclair-Collis analysis was the Secretary of State had, the Court of Appeal in Sinclair-Collis in England and Wales had treated a case of derogation in the same way as a case where a measure was being applied to implement a directive measure. And that was said in paragraph 82 to be an aspect of the reasoning that was open to criticism. The Secretary of State said that the upper tribunal was engaged in striking the balance for itself rather than considering whether the balance struck by the Secretary of State was properly open to him. That's paragraph 43.2 of the written case, Core Volume 137. On that, please can I look at paragraph 101 at MS 1391. The Court of Appeal, that is in the Lumsden case, began its consideration of proportionality by stating it is not for the court to decide whether quasar is disproportionate. We are unable to agree with that statement. It is for the court to decide whether the scheme is disproportionate. The court must apply the principle of proportionality and reach its own conclusion. The Court of Appeal relied on Sinclair Collis, that's a paragraph 102, saying that they were reviewing the proportionality of the Legal Services Board's decision. Paragraph 103, for reasons we've explained, the judgments of the court in Sinclair Collis do not provide reliable guidance as to the test to be applied in a context of this kind. And then in paragraph 108, paragraph page 1393, in the circumstances it's necessary for the matter to be reconsidered on the proper basis. In particular, firstly, it's for the court to decide whether the scheme is proportionate as part of its function in deciding on legality. In doing so, it should approach the matter in the same way in which the Court of Justice would approach the issue in enforcement proceedings, i.e. looking closely at the reasoning and the evidence on the economic and social justification for derogating from fundamental rights. And I therefore submit that there was no error in the upper tribunal finding that was upheld by the Court of Appeal, that the extension decision was an unlawful use of the appellant's power of extension in paragraph 5 of Annex A to the Act of Accession, because the workers' registration scheme was not introduced in 2004 as a check on numbers, but as a monitoring measure with a view to bringing informal workers into the formal economy. The MAC report gave only the weakest support to a suggestion that its continuation, having been repurposed as a check on numbers, might potentially act as a check on numbers. The MAC report, which is the only evidence there is of any reasoning or consideration on this, is not a delegation of the Secretary of State to an expert body to the proportionality exercise which was for him to make and then an adoption of that. The MAC was only asked if it might be sensible from the point of view of numbers to extend the workers' registration scheme, not whether it was proportionate, and the upper tribunal was right to draw attention to that lacuna in the evidence. And in the absence of any evidence that the Secretary of State had given any consideration to the other side of the balance, there was no appreciation or exercise of discretion to which the upper tribunal could have given respect in its assessment, its own assessment of proportionality. The only legitimate aim of the 2009 extension decision was to assist in tackling the actual or threatened serious disturbance of the labour market at that date. No other aim is sufficiently connected to the purpose of derogation from principles of equal treatment on grounds of nationality. So the question of whether you had other sources of information and so on is irrelevant. And I say that the upper tribunal was right in any event to consider the question of proportionality stricto sensu, and its level of scrutiny, even on a manifestly inappropriate test, was necessarily heightened because there was no appreciation by the decision maker to which the court could defer. The court will be familiar with that concept in Article 14 cases like or Strasbourg cases like misbehaving, where yes, even when making its own proportionality balance, the court will give deference to what the first primary decision maker has said, if they have said anything. But if they haven't, the court doesn't have that evidential assurance, and that case, that principle, that misbehaving principle, also applies in EU law. On that, can I ask you please to look at the Court of Appeal's decision in Elias and the Secretary of State for Defence, which is in volume 2-3 of the authorities, tab 63, MS 128 to 133. This...
Could I have that number again, please?
Yes, MS... No, that can't be right.
Can't be.
Sorry.
Doesn't sound right.
Internal numbering. Sorry. No. Sorry, I've got a paragraph number. I'll get you. Yes, 223.
It's 2294, I think.
294.
Yes, sorry, the passage I want is 2326.
2326.
So sorry, this was a case about indirect discrimination on grounds of race, which was accepted to be indirect discrimination on grounds of race, and whether there had been an error in Mr. Justice Elias's decision that was not proportionally justified as a matter of EU law. The evidence that it was justified was not evidence of contemporaneous consideration by the Secretary of State, but evidence which explained why, in the Secretary of State's view, by the time the matter came to court, there was justification for the indirect discrimination. Paragraph 128 by letter H, paragraph 2326, records a submission on that matter. What matters is that there are objective reasons for their criteria, and as such to justify the measure concerned. While I do not doubt the correctness of the general proposition that in theory ex post facto justification of a breach of interest protected by EU law is legally permissible, it does depend on the circumstances. In paragraph 130 it was said there are legal and practical difficulties in cases advancing justification that wasn't considered when the measure was put forward. Firstly, paragraph 131, the onus is on the Secretary of State to justify the measure. That's the same here. Secondly, 132, one important consequence of the failure of the Secretary of State to address the indirectly discriminatory measure is the absence of an evidential basis for justification. And then by letter F, the kind of evidential material which ought to have been available for deciding the issue of justification does not exist because it wasn't considered at the relevant time. So that principle, the misbehaving principle, applies equally in EU law. If there isn't evidence of the Secretary of State as to what his thinking was at the relevant time on the question of balance, then the court does not have the assurance of that and is not able to defer to it. And the MAC report isn't evidence of that consideration and balancing by the Secretary of State. The MAC report is evidence of the Secretary of State obtaining an opinion on whether the measure, the continuance of the monitoring measure, the workers' registration scheme, would have an impact on numbers of some kind. That's the only part of the analysis that the MAC report addresses. And the MAC report itself recognises that there will be balancing of other factors for the Secretary of State. It doesn't purport to do that itself. The Secretary of State, the upper tribunal gave a very close and considered, a detailed analysis of the MAC report, as Lumsden said it was that the court was required to do in conduct of a proportionality exercise based on economic and social justification of the measure. That's at paragraphs 104 to 119, MS 272 to 274. I don't repeat it. It was difficult to imagine a report favouring retention of the workers' registration scheme couched in weaker or more heavily qualified terms. That was an entirely permissible assessment by the upper tribunal. Paragraph 112, it correctly distinguished between that which was sensible and that which was proportionate. And and found that it failed the suitability test because it didn't properly address there wasn't a measure intended to meet an objective of limiting numbers and wasn't suitable to do that. This was an expert tribunal. It shouldn't be set aside. Its decision shouldn't be set aside unless there was an error of approach, and there wasn't one. And the Court of Appeal itself gave a close analysis both of the correct test and the proportionality exercise and decided that the upper tribunal had been correct in its approach, which it not only found no fault with at paragraph 75, MS 233, but agreed with between paragraph 77 and 79. And the appellant in this case is attempting to dress up a disagreement with the upper tribunal's factual conclusions on the strength of the justification as an error of approach. And we also gratefully adopt the Air Centre's analysis on this issue in advance. So that is our response to the appeal on grounds 1 and 2, no proportionality exercise at all, and if there is a proportionality exercise error of approach, we say yes, proportionality is the relevant test, and no error of approach by either the upper tribunal or the Court of Appeal. All that part of the case is predicated on the assumption that the Secretary of State was right to say that in order to qualify for state pension credit as a former worker with a worker's retained status, the respondent had to be exercising had to not only have worked lawfully for a year as a worker under the workers' registration scheme immediately before her retirement, which she had, but also had to have resided for 3 years in exercise of rights of residence under the Citizens Directive. And we say that that is not the right approach. The law is really that the Secretary of State needed not only to, the respondent required a year's lawful residence, a year's lawful work, and 3 years of residence simpliciter. In the courts below, this issue became rather tied up in a close, or in the Court of Appeal, which is the only court I can speak of from personal presence, the issue became rather tied up in a close textual analysis of the relationship between Article 16 and 17 of the Citizens Directive, and whether Article 17 derogated from Article 16 in terms of the quality of residence, or just the length of residence in terms of text and statutory drafting. But in this court, the issue is thankfully and properly simplified by the Secretary of State's concession, which is rightly made in paragraph 69 of the written case MS 146, that Article 17 of the Citizens Directive preserves a right introduced by Article 2.1a of Regulation 1251 of 70. Now, the reason that concession is a correct one can be seen from the text of the Citizens Directive. If I could ask you to take it up, it's in tab 1.1 of the first bundle. And start with the preambles. Preamble 3.
Page.
491. Mr. Chamberlain took you to this one yesterday.
Sorry, which tab is it?
Sorry, it's tab 1.1. Tab 1 of the primary.
Thank you. Page?
111, page 491.
Thank you very much.
So the first preamble is that citizenship of the Union confers on every citizen of the Union a primary and individual right to move and reside freely, subject to limitations laid down in the treaty and measures adopted to give it effect. Preamble 3, Union citizenship should be the fundamental status of nationals of the member state when they exercise their right of free movement and residence, therefore necessary to codify and review the existing community instruments dealing separately with workers, self-employed persons, students and other inactive persons in order to simplify and strengthen the right of free movement and residence of all Union citizens. So it's a strengthening measure, not just a harmonisation measure. And then paragraph 19, the preamble is 496. I don't think, from my note, Mr. Chamberlain took you to this one, certain advantages specific to Union citizens who are workers or self-employed persons and their family members, which may allow these persons to acquire a right of permanent residence before they have resided 5 years in the host member state, should be maintained, as these constitute acquired rights conferred by Regulation 1251 of 70 on the rights of workers to remain, and so on. So Article 17 should be seen in the light of that, which is an assumption that the rights conferred by 1251 of 70 are maintained. That's the METOC principle as well. I don't think I'd need to take you to it. This much is common ground. So that when one looks then at paragraph 17, if we start at 516 on 518, Union citizens who have resided legally for a continuous period of 5 years have the right of permanent residence there, subject to conditions. Right of permanent residence in that context that phrase in Article 16, resided legally, does not mean resided in the exercise of any old EU law right. It means resided specifically in exercise of one of the rights recognised by the Citizens' Directive. The authority for that is Zielkowski, paragraph 47, MS 1957. And so the
Sorry,
rights...
can I have the reference again, please?
1957, paragraph 47 of
And
Zielkowski.
could you repeat to me, you're going at speed
Yes.
for understandable reasons.
Sorry,
Could
yes.
you repeat the proposition
Yes.
you're making?
Article 16 provides a right of permanent residence to a union citizen who has resided legally for a continuous period of 5 years in the member state. Rights of legal residence under EU law go beyond the rights which are conferred by the directive itself. For example, there are rights under regulation Article 12 of 16, regulation 16, regulation 1612 of 68.
All I was asking
Yeah.
was a nutshell or a repetition of your initial
So
sentence.
there are other rights of legal residence, but resided legally in Article 16 of the Citizens' Directive doesn't mean an exercise of one of those rights. It means specifically resided in exercise of one of the rights conferred by the Citizens' Directive itself. The authority for that proposition is Zielkowski, paragraph 47.
Sorry, can I?
Sorry, say that again.
It's not-
Which
Ms
bit?
Mountfield, will you slow down a bit, please?
Yes.
We're all having terrible difficulty,
Yes.
both in hearing you and making a note of what you're saying.
And so what I was asking was you to encapsulate this. This is obviously very important to
Yes.
ground
Yes.
3.
Yes.
To encapsulate in a couple of sentences what it is you're saying that is the meaning of resided legally in Article 16(1).
I am saying resided legally in Article 16 means resided in exercise of one of the rights under the Citizens' Directive itself.
Thank you.
Zielkowski, paragraph 47, MS 1957.
Now, hang on. We're now trying to write that down. Then we will try and write down the authority that you give for that proposition. So resided in exercise of one of the residence rights in the Citizens' Directive itself.
Yes.
And you're going to go on to say that Article 17 is different.
Yes.
But sorry, since you've referred us to paragraph 47 of Zielkowski, it doesn't actually say that. It refers specifically to satisfying the conditions laid down in Article 7.1 of the directive. Is that because of the facts of the case, or so that's narrower than the proposition you've just given us?
Yes, well, Article 7.1 of the Citizens' Directive itself. But if you could look at paragraph 46 of Zielkowski.
Period of residence which complies with the conditions laid down in the directive. In particular, those set out in Article 7.1.
Thank you. So it's 46, in fact.
Yes, so it's 46 and 47. What Mr. Chamberlain says is that that is the primary right in Article 16 for the primary basis for acquiring a right of permanent residence. Article 17 over the page, 519. This is the derogation from Article 16, right of permanent residence enjoyed before completion of a continuous period of 5 years by workers who have been working in the member state for at least the preceding 12 months and have resided there continuously for more than 3 years. Mr. Chamberlain says that because resided legally in Article 16 is the definition of resided legally under the directive, the Article 17 should be read as a derogation only from that period of lawful residence as defined in Article 16, not a derogation from the quality of residence. But he also correctly concedes on the basis of Preamble 19, read with Article 19, that if and to the extent the rights under Regulation 1251 of 70 are wider, then they are preserved. What he says is, yes, that's right, it's uncontentious, but In fact, if one looks at the rights under 1251 of 70, they are no wider. Residence always meant lawful residence in, presumably lawful residence in exercise of an EU law right. And because he too was under some pressure of time, I'm not sure he took you to 1251 of 70. May I take you to it? It's in volume 1, tab 3. It starts at MS 538. Preambles, the third preamble explains that the right of residence has a corollary right to remain, having been employed in the state, and it's important to lay down the conditions for its exercise. At the top of the second column, it's important to guarantee the worker residing in the territory of a member state the right to remain in that territory when he ceases to be employed in that state because he has reached retirement age. And pausing there, that may be less important nowadays than it was when that was introduced, but of course in those days retirement age meant you had to stop working. There was no question of having to have an age-justified reason for forcing somebody to stop when they reached a particular age. MS 539, Article 1 says that the provisions of this regulation shall apply to nationals of the member state who have worked as employed persons in the territory of another member state. So it implies to all people who have worked as employed persons, and then sets out in Article 2 who shall have the right to remain permanently in the territory of the member state. A worker who at time of termination has reached the age laid down by the law of the member state for entitlement to an old age pension, has been employed in that member state for at least the last 12 months, and has resided there continuously for more than 3 years. How do you decide if somebody's resided there continuously for more than 3 years? Article 4, continuity of residence may be attested by any means of proof as in use in the country of residence. So it implies it's a question of fact to be proved in a non-discriminatory way by whatever means the member state uses for proof. And just to complete this...
Sorry, why does that mean that it's a question of fact as opposed to... It depends what you're trying to prove, doesn't it?
Yes, it doesn't say what you're trying to prove, but
it doesn't say whether you're trying to prove actual residence or legal residence. Are you saying just actual residence? That's all it is.
I am saying it's actual residence. I'm not drawing enormous assistance from Article 4, but I'm saying since it's a question of proof, it's that gives I get some assistance from that. The way that provision is carried over into national law is in the 2006 regulations in the same volume. Tab 8, it starts at the bottom of MS 641, a worker or self-employed person who has ceased activity and in those regulations, regulation 642, a person satisfies the conditions of this paragraph if he terminates his activity as a worker, has reached the age at which he is entitled to a state pension on the date when he terminates his activity, and B, pursues his activity as a worker in the United Kingdom for at least 12 months prior to termination. So pausing there, for an accession state national, that has to be a worker working as registered under the Workers' Registration Scheme for this aspect of the case, because otherwise not defined as a worker. And C, resided in the United Kingdom continuously for more than 3 years, prior to the termination. And just for completeness, that could mean something wider than the meaning of residence in Article 1251 of 70. I accept, of course, that it is most probable that the meanings of the regulation in the 2006 regulation in national law and 1251 of 70 and 17 are the same, but it's not necessarily the case because if one turns to the final reference in the Citizens Directive, MS 534, Article 37, the provisions of this directive shall not affect any laws, regulations, or administrative provisions which would be more favourable to the persons covered by this directive.
Five, 3, 4.
5, 3, 4.
I'm lost.
Secretary of State argues that the limitation of residence, meaning lawful residence in Article 16 of the 2004 Citizens Directive, should be implicitly read back into 1251 of 70. It was always the case, he says, that residence in EU law should have been residence in exercise of that EU law right. But, firstly, unlike Article 16, which Article 17 is in the same instrument, in 1251 of 70, there is no reference anywhere to legal residence, which could in principle be read across into Article 2(1)(a). In contrast, there is a clear distinction between the requirement of exercise of an EU law economic right, a right that arises from being employed as a worker in a state for at least 12 months, and residence. I've made the point that legally resided in Article 16 means resided in exercise of one of the rights in the directive, and there were no such rights when 1251 of 70 arose. So 1251 of 70 resided there continuously in that instrument can't sensibly be taken to mean resided there in exercise of some unspecified range of EU law rights. Could it be argued then that Regulation 1251 of 70 residence must be residence in exercise of some kind of EU law right? I say no, because unlike in Article 16 of Directive 2004 of 38, there is no textual basis for any such argument. The Secretary of State says there is a need for some kind of integrative link. So the residence would need to be residence in exercise of an EU law right, because one needs that to make there to be some kind of integration into the community. But that isn't right. All he has to rely on that is the Givane case. Can I take you to MS 147, paragraph 73 in the appellant's case.
The tab, please.
It's in the core volume, page 147. It's in the Secretary of State's case. That's what the Secretary of State says on this matter. But if I can ask you then to go to Givane, it's in volume 1, 2, tab 16, MS 1008 sets out the issue in that case. This is the head note. Mr. Givane was a Portuguese worker who had lived and worked in the United Kingdom between 92 and 97. He went to India, stayed there for 10 months, came back with his wife and 3 children who were all Indian.
986.
986.
And then he died. Oh, I'm sorry, did I give the wrong page reference?
Yes.
I did. So sorry. 986. And then he died. And death was not caused by an occupational disease. And his family applied for indefinite leave to remain under Article 3.2 of Regulation 51/70, relying on their right of residence as family members of a deceased worker. He was a worker at the date of his death, but he needed, under Article 3.2 of the regulation, to have lived in the United Kingdom for 2 years before his death in order to, for the family to acquire the derived right to remain. The case for the family was he did live in the United Kingdom for more than 2 years. It just wasn't immediately before his death. So the issue, I took it from the head note, but it's summarised by the court in paragraph 17, which is at MS 1008, the question whether the period of residence must immediately precede the death of the worker. Paragraphs 22 and 23 on that same page record the submission of the United Kingdom government that continuous residence must start at the moment when the worker entered the member state concerned. And the reason they said that, paragraph 24, was that the objective of the regulation was intended to ensure that the right to reside may be exercised only if the persons concerned have established a significant link with that state and if there has been a certain putting down of roots in it, which that stability was shown in this case by the requirement at the date of the worker's death of a continuous period of residence. So it appeared to be accepted or positively submitted in that case that the residence was necessary for a putting down of roots, not just the exercise of the economic right as a worker, but for some putting down of roots. Paragraph 34, therefore set down MS 1010, set down the disagreement on the literal interpretation of at least 2 years. And at paragraphs 47 through to 49 on MS 1012, paragraph, in fact, if I take it from the bottom of paragraph 46, the court found that the condition was intended to establish a significant connection between, on the one hand, the member state, and on the other hand, the worker and his family, and to ensure a certain level of integration into the existence of the society of the state. The community legislature sorry, this is the family's submission. They said that the departure of the worker for a period of 3 months should be subject to some form of limitation, which would that would introduce into Regulation 1271 criteria which do not flow expressly from it, and that would create uncertainty as the legal position. And then the court said, furthermore, if the community legislature had wished that periods of residence further removed from the date of the worker's death could be taken into consideration, it would have been appropriate to include in the wording of 1251-70 an express time limit. So the worker lost. And I rely on that to invite you not to read in language that isn't there. If the court had wanted to say residence in exercise of EU law rights, it could have said that, and it didn't do that.
You said the court to, if the legislature had wanted to.
Sorry, if the legislature, yes, I'm so sorry. Yes. The Romero case at tab 23 is also a case in the respondent's favour on that, for reasons which I've set out in my written case, paragraphs 104 to 108, MS 187 to 188. I draw your attention to the Advocate General in that case. This was a case about whether one needed to have established a permanent right to reside for 5 years before one could rely on the permanent leave to remain for 10 years and much stricter conditions for removing you in circumstances of public interest. MS 1208. Tab 23.
Sorry, which bundle, please?
I'm sorry, my lord, I'm just losing my bundle reference.
It's tab 23.
Tab 23, I think it's volume 1, 3.
It is.
1, 2. Yeah. Okay, 1, 2, I'm sorry.
1, 2.
This is back at 1, 2. Tab 23. It was a case about whether you needed to have a right of permanent residence in a host state acquired by 5 years of lawful residence before you could get enhanced protection acquired after 10 years of residence from removal for public interest reasons. in paragraph 67 of the Advocate General's opinion, MS 1208, the paragraph 67 and 68, paragraph 67 at the bottom of the page, the court held that for the purpose of establishing residence, it must be ascertained, sorry, not the Advocate General held, gave a view that it must be ascertained whether the absences during that period involved a transfer to another state of the centre of personal, family or occupational interests of the person concerned, i.e. residence is the centre of your personal, family and occupational interests. And it seemed to him, in paragraph 68, that, by letter C, that the question was unconditional continuity of presence in the host member state during the previous 10 years. And the court said nothing to oppose that. Now, the question then is as to who would be excluded from this protection if the Secretary of State's definition were right.
Forgive me, Ms. Mountfield, I don't understand what proposition you extract from Romero.
Sorry, I was drawing your attention to the view of the Advocate General that residence was equated to the centre of someone's personal or social interests and continuous presence in an established way. And there's nothing in the judgment of the court that departs from that. But I
thought you were relying on the reference to presence in 68.
Yes, and I was relying on the reference to presence.
Which is a strange word to use if you're really meaning legal residence.
Yes, my lord, my lady, I'm sorry. And
Yes,
my submissions on that, which are MS 187 to 188, say that in Romero that meaning of residence was being used to provide a qualitative element in relation to integration in the member state. In Givain, the period of residence had to be immediately before the death because of the qualitative element. But in this context, the qualitative element and the link to the EU as an economic order is given by the 12 months of work. This is about a level of social integration and presence. And I am relying on the question of presence, but I emphasise in paragraph 108, on page 188, that we're not saying that presence, 3 years of presence on its own would be enough. We are talking about that as the territorial and temporal component of the link, which is satisfied, and the economic link is satisfied by the 12 months of work. There's nothing in the language to suggest to the contrary. Now, I'm very sorry that I haven't been able to do this before, but unfortunately, the delay in getting material to court. I hand up a short written list of examples of circumstances which would be, my learned friends have, of circumstances which would be, of circumstances which, if the Secretary of State were right, would be cases where a person who was not resident in exercise of an EU law right, but was resident for more than 3 years and was working lawfully as a matter of EU law immediately before retirement for a period of more than 12 months, would be excluded from the protection of 1251 of 70, and ask if there are public policy reasons for that. Now, I remind you, this really goes to the regulation 2006, the domestic 2006 regulations, of the two definitions of residence in English law, and I have copies of those authorities, not electronically, of course, yet, but those, I will make sure that that is done. But the
Are we to take it that the Secretary of State was provided with this before the
Yes,
hearing?
yes, he was. Yes, he has been.
Because
Not very much before. Yes, at about 9 a.m. As Mr. Chamberlain
plenty of time.
says. I hope Mr. Chamberlain isn't taken by surprise by the references to residents in Shire and Cornwall, because the reason I put those in is because ordinarily resident means a man's abode, a person's abode in a particular place or country adopted voluntarily and for settled purposes as part of the regular order of his life, whether for short or long duration, subject to the ex terpi causa principle. If somebody's there in breach of immigration law, shouldn't be there, then they can't rely on that residence. And then in the Cornwall Council case, which was about a person who lacked capacity, the starting point is rather different. The place may be where somebody eats or sleeps because the voluntariness may not be there. The question is a degree of integration. But I put in those cases because I do accept that if someone was there unlawfully in the sense of having come in illegally as an illegal immigrant, they couldn't rely on their presence, their mere presence, as lawful residents. But I do say that there are all sorts of ways you can be lawfully in this country without exercising a right in EU law. And I ask whether there's anything in the language or the policy of Regulation 1251 of 70 which suggests that such people should be excluded. And I've given some examples. The first is someone who comes to the UK from France, works for 9 months and then loses their job. They live here, they have savings, but they don't satisfy the criterion of being fully independent, self-sufficient, and not dependent on the state because they don't have comprehensive sickness insurance. They live here in that way for 18 months, then start work for 15 months and then retire. That would be excluded on the Secretary of State's construction. Then what happens if somebody who's an EU national comes the dependent of a third country national spouse who has leave to remain in the under the Immigration Act, as do their family? Then the spouse dies, and that person who is an EU national is entitled to work lawfully, starts to work and then retires. Is that a situation where the residence should not be treated as establishing a relevant connection for the purposes of 1251 of 70? He said there are potentially EU law rights of residents which are not exercise of rights under the Citizens Directive. That's the third example. Somebody who comes, works as a year, and then spends a year as a primary carer for a child. If you're here as the primary carer for a child, you are allowed to stay under Regulation 12, Article 12 of Regulation 1612 of 68, or at least you were at the relevant time, but that is not a right which was transferred over to the Citizens Directive. So it wouldn't count as lawful residence for the purposes of Article 16. That person then takes up work again and then retires. Again, on the Secretary of State's construction, wouldn't be allowed in. Then there is somebody who has exercised a right of residence in domestic law, not conferred by EU law. That's the fourth example. A third country national who comes to the UK from another EU state, Belgium, and is granted 3 years leave to remain. After a year, through whatever route, by naturalisation or marriage or whatever it may be, he becomes a Belgian national. His leave to remain isn't revoked, but when it ceases, he then spends a year working and then retires. Again, that would be perfectly lawful residence, no ex terpi causa principle, but on Secretary of State's construction, that would not count. And then finally, finally we have somebody who's an accession state national who comes to the UK before accession, works under a work permit, which expires just after Poland accedes to the EU, then works for 2 more years in exercise of EU law rights to work, and then retires. And that would not count on the Secretary of State's construction. There's another example, which is based on the Miscavige case. I mentioned that judgment of Lord Justice Elias yesterday, and I've got a copy of it. That was the case where he said that Article free movement rights were preserved, except to the extent that they were limited by transitional measures. But you might well have someone, say someone who is a member of the Roma community, who came to the United Kingdom and sought asylum from somewhere like the Czech Republic in 2003. Their asylum claim is refused. These are the facts of the Miscavige case, but they are granted, pending appeal, they're granted temporary admission and a right to work. So they're here lawfully as an asylum seeker with an outstanding right of appeal. They're working lawfully. While that appeal is outstanding, the Czech Republic becomes a member of the EU. That person signs the registration, the Workers' Registration Scheme register, and works lawfully for a period of less than 3 years before retiring. So only those 2 years have been an exercise of an EU law right, but they've been here and working lawfully all the way through. But the work, and the Miscavige is the authority for this, only the work as an EU worker, an exercise of an EU law right, counts as lawful work for the purposes of work as a matter of an EU law right. Is that also only the residence that arose from that work that counts, or could the previous period of totally lawful residence be relied upon as well? Absolutely no policy reason in my submission why those periods of lawful residence shouldn't be counted, and there's no indication anywhere that they won't be, no linguistic indication. So for that reason, in my submission, Upper Tribunal Judge Ward was right to find that the appellants tolerated residence in the United Kingdom, actual residence, met Article 17 conditions for residence, and I note that he relied on the finding of a tribunal of commissioners, including the President and the Vice President of the Immigration and Asylum Chamber of the Upper Tribunal, who came to the same conclusion in the case of MAH. I propose to take you to it unless you want me to. I will if you do. It's paragraph 26, MS 2397.
I may be losing track, but in your written case, you were arguing that there was a difference in the meaning of residence between Articles 16 and 17. Are you now saying a proper understanding of Article 16 gets you home and there doesn't need to be a difference between Article 16 and 17? Or have I misunderstood you?
No, my Lord, I'm saying that in Article 16, the residence, the quality of residence is specifically on the language of Article 16 of the Citizens Directive is resided lawfully.
Yes,
lawfully,
but you say lawfully has a broad meaning.
No, I don't.
You don't?
I say
I misunderstood
that was my Ziolkowski point. For the purposes of Article 16, lawful residence is residence in exercise of a right under the Citizens Directive only.
Yes.
By way of derogation from that, Article 17 provides a right to remain for someone who has only 3 years residence and a year of lawful work.
Okay.
Does one then read the word lawfully across to Article 17 because it's said to be a derogation from Article 16, so the missing word lawfully in Article 17 should be implied into Article 17? That's the Secretary of State's submission, and it attracted the Court of Appeal. I say you can't read Article 17 as only derogating from Article 16 and using that language once you bear in mind that Article 17 is preserving rights. What right is it preserving? Rights under 1251 of 70. Look at 1251 of 70, where there's no reference at all to legal residence, just residence. Then I ask, is there a policy reason to imply legally? And I say not, and certainly not a policy reason to imply only in exercise of some EU law right. Yeah. And the fact that that derogates from the generally required scope of lawful residence in Article 16 is not in itself a policy reason not to allow that, not to give it the reading that the natural and ordinary language of Regulation 1251/70 requires. And on that, I refer to the speech of Lady Justice Gloucester in RM Zimbabwe, which is at MS 2523, and it's in volume 2.3. It's in tab 2, sorry, it's in volume 2.4, tab 71.
Page?
The page is 2523. This was again a case where the acquisition of a right of residence depended on when residence had occurred. Did a spouse acquire a right of residence derived from being married to an EU national based on periods of residence before that marriage? It was said that that would be extraordinary because it would lead to wider rights than those available under the Citizens Directive.
Sorry, where are you on the page?
I'm summarising in a moment. Then 25323, my lord.
Yes.
523, paragraph 31, subparagraph 8. Use of the word had acquired has to be interpreted having regard to the right of permanent residence at the time, because there was no temporal condition or limit stated within Article 17.3. Had it been intended to include such a condition, it would have been expressed within Article 17 and reference to METOC, and sorry, going backwards, I'm so sorry, at the bottom of 2522.
Forgive me, isn't this setting out one side's argument?
Yes, but it's accepted by the court.
Oh, is it? All right.
Why do you need this? I don't.
I don't, my lord, but I'm relying on it in another context, in distinguishing between paragraphs 2, 3, and 5 of Annex 8. Mr. Chamberlain drew some quite nice linguistic distinctions between the language used in relation to the link between the circumstances required, between paragraphs 5 and 7, between the circumstances in which a power could be used or where it was merely a condition precedent that there was some sort of disturbance in the labour market, and relied on the proposition that if words are intended to be put into an EU legal instrument, they are put in. That's the point that was also made in Gervais.
I mean, surely your point is quite a simple one.
Yes, it is.
Which is that, let's keep it that way, that under the paragraph, the sort of link between 16 and 17 is slightly misleading, because 17 is actually derived from a different source, and everyone agrees you've got to go back to the source to see what it meant, and that's exactly what Upper Tribunal Ward did, and he set it all out.
Yes.
And you adopted his reasoning, I suppose. But, I mean, are you saying it's clear enough for it not to require us to refer it?
That was my next point. If you think it is clear enough and that derived from general principles of EU law, an ordinary word like residence can be defined on its own face, and it doesn't say lawful residence, then simple residence is enough, then you don't need to refer it. If you are not sure, then being the final court of appeal, if this is the basis upon which you were minded to find for the respondent or the appellant, then you would need
yes, so you're adopting the normal submission that it's jolly clear, but if it isn't clear, then we should refer it.
Yes, absolutely. So it's completely clear in my direction, if not, you should refer it. But only...
Both sides always submit.
Yes.
I just wanted to put it to you. Because
but only if it's determinative.
But only if it's dispositive. And I say that you don't need to refer it for 3 reasons. One, because the appellant ought to fail on grounds 1 and 2, at which point anything you said on this, you might not need to say anything, but if you did, it would be strictly obiter.
Thank you.
But finally, because I say I can rely on the language of Regulation 5 of the 2006 Immigration EEA regulations read on its own. The word residence there being interpreted in accordance with the ordinary meaning of residence in Shah, this not being an ex terpei causa case. Mr. Chamberlain says, can't do that. It's gold plating, the language of the directive. Clearly, the 2006 regulations were intended to transfer across EU law rights, and it can't mean anything wider than what EU law rights mean. I accept that the purpose, the broad policy intention of the legislator in setting out the 2006 regulations was to give effect to EU law, but to the extent that by clarifying the word residence, or setting it out in plain terms that have an express meaning in domestic law, they have gone any wider than EU law. That doesn't make it ultra vires Section 2 of the European Communities Act and the power to transpose the Citizens Directive, because the Citizens Directive expressly says in Article 37 you can go wider in your domestic regulations if you want to do so. So another way that you could avoid a reference is by saying whatever residence means in 1251 of 70 and Article 17 of the Citizens Directive, it's a plain word in English law, it has a meaning except in cases of illegal residence wrongfully pursued, and we could decide for the respondent on the plain language of the 2006 regulations on its own. I think I have 4 minutes left.
Not according to this. Oh, you
Because
started
of-
a bit late.
because of-
You
because
started
of-
late,
because-
yes.
because of-
Three
because of
minutes.
Mr. Chamberlain's-
3 minutes.
Yes. I know they're not my minutes. I know from the Miller case, they're not my minutes to confer, but if Mr. de la Mare were to need them, I would have no objection to him taking those minutes. If you had no objection, I know it's in your gift, not mine.
Thank you very much.
Unless I can assist you further, those are my submissions.
I think we've put all our questions to you. Thank you very much indeed. Mr. Royston? Mr. de la Mare.
President, members of the court, it's seemingly common ground that the decision to continue the transitional measures required to be justified. It's equally common ground that if justified, then such measures are, during the derogation period, thereafter lawful for all purposes, such as to not require separate justification under EU law. But the debate between us is really about what are the requirements of that process of justification, and what's more, I suspect, over the law that controls that process of justification, be it EU law or domestic law. The Secretary of State's case is beguilingly simple. She says that all that is required for justification is the establishment of 2 prior factual conditions precedent. Condition 1, that there should be a serious disturbance of the labour market or a risk thereof. That's a factual condition precedent. And secondly, that the Commission has been notified of the measures. Now, those are 2 criteria supplied by the Treaty of Accession, presumably as given effect as a treaty so designated through Section 2.2 of the European Communities Act, and they're admittedly criteria of EU law. But beyond that, the Secretary of State says that nothing is required by way of justification, and that the process is controlled entirely by domestic law, such that there is, and I think it was conceded orally, only liminal control through the principles of rationality. Our case, by contrast, is threefold. Firstly, we say that the only purpose or legitimate aim for which measures may be continued in the last 2 years is as a transitional measure to contribute materially, and I emphasise the word materially, towards removing, preventing or mitigating the serious disturbance of the labour market. Secondly, we say that the national measures adopted must be capable, as a matter of EU law and assessed using techniques of EU law, they must be capable of achieving that aim. That is, they must affect the serious disturbance to a material degree. And I note, in answer to the questioning of your lordships this morning, in particular Lord Sales and Lord Hodge, that Judge Ward found in terms that the measure failed that test of suitability at paragraph 1112. His reasoning wasn't just about proportionality strictu sensu, it was avowedly that this measure was not fit for the purpose for which it was intended.
But I think the question is whether he was right about that.
Indeed.
There are 2 limbs to his proportionality
Indeed.
analysis.
Yes, And I am principally concerned with defending his reasoning in relation to the first limb, suitability. Thirdly, we say, like the respondent, that thereafter the principle of proportionality applies to then assess whether the gains produced by those measures in terms of protecting a seriously disturbed market are sufficient to justify the harm done to A8 workers by delaying their full transition to ordinary EU workers with the concomitant rights that status entails. Now, I'm going to concentrate on the first 2 points, but what is of note that is omitted from that analysis is any analysis of least restrictive means. And that is because in the grand panoply of proportionality cases, this case is distinctly anomalous, because invariably, when faced with a measure, you are complaining about the reach of its effect and you propose an alternative, less restrictive measure. So, for instance, in Quasar, the less restrictive measure was a different form of assessment, not involving judicial evaluation. In Sinclair Collis, it was a means of ensuring vending machines weren't being used by underage smokers. Here, there is no candidate less restrictive measure because the measure itself is so marginal in its effects, so close to the point of zero effect at all, that there is no lower place to go.
But I mean, that's because that's where we're at. That's because of the decision made before. You can only continue what's there. I mean, he's got the choice either of continuing what's there or getting rid of it, or taking the rather drastic step, which now one suggests, of suspending the whole operation of the scheme altogether by permission of the Commission. So there's nothing very surprising about it there.
With respect, my Lord, that analysis is not correct, because what the House of Lords was told in Zalewska was that the whole purpose of the monitoring function was to detect whether or not inflows of labour produce distortions in the labour market, in particular sectors, occupations, or in general, that would justify having recourse to more intrusive measures. In other words, it was early warning data that then would trigger the option of doing something more serious. And so what must have been in contemplation in that argument is using one of the overrides that the scheme of accession provides. And there are two overrides. Article 37, which applies during the first 3 years, and it's a totally general override by reference to all community rights. And then paragraph 7 of the accession, which lasts for 7 years and provides an override in circumstances where there are threatened serious dislocations. Now, we say that option was always open to the United Kingdom.
You're not saying that they should have exercised, or
No.
they would have been proportionate to exercise it, right?
No, I'm not suggesting that it was proportionate.
So why don't we concentrate on the thing we are dealing with, which is the limited power to extend for two years, a power that's in a case where they've got admittedly serious disturbances?
Absolutely. So in whatever they're responding to, it wasn't thought so serious as to justify for reaching for something more serious in the weaponry. Now, standing back, what is significant about the Act of Accession?
Sorry, I mean, just on paragraph 7, I thought that's action by the Commission, so not by the Member State. The Member State raises an issue with the Commission. It's actually, from memory, somewhat different preconditions, and then it's the Commission that suspends.
No,
not
the Commission is involved in the process of scrutinising and approving the measure. So if one turns up bundle A11, tab 4, page 597, MS 597, the condition is worded as follows. When a member state referred to in the preceding paragraph, that's one that's given full access, undergoes or foresees disturbances on its labour market which could seriously threaten the standard of living or level of employment in a region, that member state shall inform the Commission and the other member states thereof and shall supply them with the relevant particulars. On the basis of that information, the member state may request the Commission to state that the application of 1 to 6 is to be wholly or partially suspended in order to restore to the normal situation in that region.
Yeah, but then read on. The Commission shall decide on the suspension.
Yes, so
that's what I was putting to you. The Commission is asked to do something which it may or may not do. It's not actually a measure the Member State can take itself.
Absolutely, but what the process is one of reasoned application where you say this is what we need to do, and the Commission either approves it or refuses it.
Yeah.
Exactly.
And we saw an example of that in the Commission decision that Ms Mountfield referred us to.
Yes, Commission in
In
Spain.
relation to Spain and Romanian workers.
Yes.
And I think in the passage you just read to us, that was the point I had in my memory, that actually the precondition is different under paragraph 7 from that.
And the reason why it's
paragraph
different,
5.
with respect, my Lord, is that the structure of these provisions is a ratcheting system where you start from the pre-existing national measures and incrementally at various points, accession, 3 years, 2 years after that, and 7 years, you ratchet towards a position of full integration. And what's exceptional about Article 37 and Para 7 is that they are the only means by which to undo the ratcheting process. And the ratcheting process is complete and inevitable once you take into account the effect of paragraphs 12 and 14. And in particular, 14 says the effect of the application of paragraphs 2 to 5 and 7 to 12 shall not result in conditions for access for Latvian nationals to the labour markets of the present member states which are more restrictive than those prevailing the date of the signature of the treaty. So you start with the conditions at the accession point and you ratchet towards full membership. But what's unusual about this process is what the derogation does is that it makes permissible as legitimate considerations factors that would ordinarily be completely forbidden from a community law perspective. Ordinarily, community law does not permit the management of migration of EU nationals to permit social harm. Avoiding disturbances on the labour market caused by movements of EU nationals is not a legitimate basis for restricting free movement. And that's that very fact that has informed much of the Brexit debate. So we have a ratcheting system with 4 steps, and what we've done, and I hope it's of assistance, we'll supply larger print copies, is reduce this to a page of analysis that shows the various stages by which the ratchet is tightened. And that being so, we say paragraph 5 cannot be looked at, as the Secretary of State encourages you to do, in some form of splendid isolation. Its purpose has to be gleaned from the structure and operation of the derogation as a whole. Why? Well, firstly, that's how derogation schemes are generally operated, and you can see that philosophy in the Kapal case, which is Bundles Authority 1.2, tab 17, MS page 1031. The relevant passage starts at 18. Here, they say of the relevant derogation, the derogation must therefore be interpreted restrictively. And then this, moreover, the derogations permitted by the Act of Accession from the rules laid down by the treaty must be interpreted in such a way to facilitate achievement of the objectives of the treaty and the application in full of its rules. And what that's saying is it must be interpreted so as to facilitate that ratcheting effect towards full transition. And they go on to say at 21 that the fact that during the transitional period traders were able to avoid paying the Finnish customs by routing the goods via another member state, such they were goods in free circulation, cannot justify the broader interpretation advocated by Finland. Given the importance of free movement of goods between member states, a derogation, even if temporary, must be granted clearly and unambiguously. And that, we say, is the true flavour of all of the case law here. It's not Mr. Chamberlain's look for the wording that appears from the text, and only if there is a condition there do you apply it. Secondly, the second reason why you can't look at paragraph 5 in isolation is because the CJEU itself has done the exact converse in the Vico Plus case. Again, A1 tab 2.2, tab 22. Now, Vico Plus was a case about the equivalent Polish provisions. Paragraph 2 and 5 of the Polish annex were in identical terms to the provisions of the Latvian annex. You can see that from the court's recitation of the facts. what does the court say in relation to that paragraph 5? Well, at paragraph 34, it relies upon paragraph 5 as exemplifying the whole purpose of the entire derogation.
Could you give us the MS number, please?
The MS number, my lord, 1183.
Could you repeat your submission?
Yes, it relies upon paragraph 5, which is in exactly the same terms in the Polish provision as it is in the Latvian provision, as exemplifying the purpose of the derogation as a whole. Because when looking for the purpose, which it uses to answer the question, should posted workers be treated as being workers, paragraph 34, it says, such a finding necessarily follows from the purpose of that provision, that's paragraph 2, which is intended to prevent, following the accession of the European Union of a new member state, disturbances on the labour market of the existing member states due to the immediate arrival of large numbers of workers who are nationals of the new states. Then this is the critical passage. That purpose is apparent inter alia from chapter 2, paragraph 5, i.e. the very provision we're looking at now, insofar as that paragraph provides the possibility for a member state, in the case of a serious disturbance of its labour market or threat thereof, to continue to apply the measures referred to in chapter 2, paragraph 2, until the end of the 7-year period. So what they're doing is using the purpose that they find so clear from paragraph 5 to read back that purpose into paragraph 2. The notion, therefore, that there is no EU law purpose in all of this is, with respect, hopeless. The only real question that arises in my submission is whether at the paragraph 5 stage, compared to the paragraph 2 and 3 stage, the range of permissible considerations has narrowed. And in our submission, it does, because at paragraph 5, you are only concerned with measures that may address, mitigate, etc., serious disturbances of the labour market. Now, in response to that, the Secretary of State says in terms, no, any purpose will do. Indeed, it goes so far in section 6 of the reply to say there is no limitation on the purposes that may be served by national measures. That's a pretty bold submission, we would suggest, against the backdrop of this derogation, but it's hopeless in the light of VICO Plus. What then causes this coyness on the part of Secretary of State to the question of purpose? What really drives all of this? Well, we think the answer is pretty obvious. If it's EU law that sets the relevant purpose, and therefore logically polices the process of justification, you've taken an inexorable step on the slippery slope to proportionality being applied, and you've lost, effectively, ground one of review. Because once you've conceded that the purpose is governed by EU law, it must be EU law that offers the control over it. And therefore, you're inexorably drawn into a balancing exercise that asks whether the marginal gains in mitigating labour market conditions are offset by the costs to the AA workers. And there's nothing so very different about that balancing exercise other than the fact that you're allowed to look at interests that in an ordinary community law context are impermissible. What then of the Secretary of State's wider answers? Well, the first contention is that our focus on material contributions and non-de minimis effects is somehow self-serving, that we're using that to game our attack on the MAC report that follows. Well, I think there's a number of answers to that. The fact that this derogation is concerned only with potentially substantial effects or substantial impacts on the labour market is shown, if nothing else, by the wholesale exclusion of Malta and Cyprus from the operation of these derogations. Why? On account of their size. Why? On the obvious basis of a value judgment that whatever happens in relation to Maltese and Cypriot nationals, they can't tilt the balance for any one of the relevant thresholds in the derogation. And that's a reflection of the fact that the population of Malta is about 450,000, of Greek Cyprus about 800,000, excluding 300,000 Turkish Cypriots, whereas the populations of, say, Lithuania, Latvia and Estonia range from 2.8 million down to 1.3 million. So proportionality and substantial effect is built into the very states to which the derogations apply. And the view was obviously taken that even major flows from those small states wouldn't be sufficient to justify the the lack of immediate conferral of rights. Secondly, it's answered, we would suggest, by the CJEU's case law on the quality of evidence that is required to substantiate a derogation. And the relevant passage is the citation in paragraph 56 of Lumsden, A1.3, tab 29, from the reasoning of the Court of Justice in the infraction proceedings in Commission and Luxembourg. And it's probably as well, just to turn that up very quickly so you can see what I'm driving at. Relevant MS page number for that reference is at 1380.
The bundle?
Bundle 1.3, tab 2029.
Thank you.
And it cites paragraph 51 from the Court of Justice's reasoning. It has to be remembered that the reasons which may be invoked by a member state in order to justify a derogation from the principle of freedom to provide services must be accompanied by appropriate evidence or an analysis of the expediency and proportionality, and precise evidence enabling its arguments to be substantiated. And that then is further explained at paragraph 57 and a reference made to the precautionary principle. So EU law controls the quality of evidence. And thirdly, for those who have to grapple with EU law on a more regular basis, the frequent invocation of de minimis principles for effects on interstate trade is a recurrent feature, at least, of the competition and state aid rules. And we suggest that the answer the CJEU would give as to whether a marginal and hypothetical and entirely speculative gain at the margins, to quote the MAC report, is sufficient to pass limb 1 of the proportionality test is blindingly obvious. And if you don't agree with me that it's blindingly obvious, that too is probably a referable question.
Yeah.
Well, I might as well make the usual submission.
Why not?
Why not? That threshold question is ultimately a question of EU law because, as Judge Ward put it, it's difficult to conceive of evidence any weaker than the MAC report. It really is couched in conditional and speculative languages at every material juncture. If that passes the test, absolutely everything, bar the total absence of evidence, will pass the test. So what then of that evidence? Two precautionary factors before you start grappling with the MAC report. The first is what one might call, in another context, the bait and switch of the purpose behind this provision. Because when this provision was explained to the House of Lords last time we were looking at it, it was explained on the basis that it was a simple monitoring provision designed to keep an eye on having cast the gates wide open. It's a bit like the city gates being thrown open to the throng outside and a gentleman with a clipboard at the gate counting the number of people coming through. And yet the argument has now become that the person with the clipboard standing on the edge of the flow of traffic is to a minor degree impeding the flow of traffic into the city, and for that reason his continued presence should be recommended. That really is, when one strips it down, the essence of the argument.
I thought he was extracting £90 a go.
He's extracting £90 a go. The MAC report is very clear about the effect of the £90 a go. It's a drop in the ocean compared to the income differentials between Latvia and the rest of the accession states. That is made plain by Chapter 4 of the report, which you were not referred to by Mr. Chamberlain, and which looks at the income earning differentials and points out that £90 is about 1% of the differential in terms of annual income that might be earned by Latvian working in the UK as opposed to Latvia. It's about the price of a return trip from Stansted to Riga. So It probably means one trip less home. The idea that that's going to impact upon your decision as to whether to relocate and work abroad is,
why
as
do
the
you need
MAC
to go into all
report...
this? We've got the MAC report. It's, as you say, very weak. You don't need to rubbish it. It's a perfectly serious report by an independent group.
I'm not sure you are rubbishing it, are you? I think you're saying
just
that this is
pointing
what
out-
it means.
I'm pointing out its limitations.
Well,
It's
no,
not a
we can
question
see
of-
those for ourselves. I mean, your point can be made perfectly straightforwardly by looking at the MAC report and seeing what it says.
I agree with respect.
You know, all this
But
sort
the
of stuff.
reason why I think fine forensic detail or attention to it is required is because I'm very much in the case of once bitten, twice shy. Because in Lumsden, we didn't really look at the material, and it was, as I recall submitting, scantily thin. Here, I really urge you to do so, because really, my learned friend's main argument is, I win on proportionality, that decision is referred, and therefore we don't need to refer because there's an error. And I'm saying, look at the material, grapple with it closely, because what it does is substantiate entirely both of the central planks of Judge Ward's analysis. This measure wasn't fit for purpose, and it plainly fails any balancing exercise if that applies. The report, and
I mean, clearly, if you're right on your central point, that it's got to do something materially substantial, it doesn't get home and you win. I mean, that's, you know, the question is really whether that bit of upper tribunal Judge Ward's assessment was right. If, on the other hand, the objective is much more limited, as Mr. Chamberlain says, well, then you lose. I mean, it's not a complicated issue. It seems it's a short issue, and it's a difficult one. But it's
at the risk of trying judicial patience, can I just point you to the central
I think it's only mine. You can
Mm.
try it
The
out
rest
on
of
the
us
others.
the rest of us are
loving
sitting
it.
quietly, yes.
The rest of them are loving it.
Or enjoying the show.
I'll go for the remaining.
I'm not sure
remaining
Mr. Chambers
six
is,
and
because
seven.
his head is in dire danger of being knocked off by you.
I'm grateful. Page 307
Page?
of MS 307. This sets out the theoretical considerations. Now, I ask you to note the following. The first
So sorry,
3.16
which bundle are you?
of the appendix. It's MS page 307.
It's the core volume,
bundle.
core
And
volume
it's
at
page
306.
95 of the appendix. MS 307.
Yes, thank you.
And there are listed here 6 factors, the first of which may all operate, or might in theory operate, to restrict flow. The 5th plainly operates in the other direction, and the 6th might operate either way, depending on how it impacts on employer demand. So increased loyalty of employees, cheaper employees might pull one way, burdensome regulation might pull the other. And yet from that set of competing factors, they say at 317, the above implies that all else being equal, the removal of WRS will cause a rise in flows. That's a simple flaw in logic, because you can't reach that conclusion without working out whether or not factors 5 and 6 are outweighed by factors 1 to 4. And it's striking to contrast that with paragraph 319, which, when faced with competing factors, said, we can't tell. Then
That does sound as though you're trying to rubbish the MAC report. I hadn't appreciated it was part of anyone's case to say that what they've done is irrational.
I'm not saying that they're irrational. I'm just simply pointing out that there is, in that respect, a want of logic. But then we look at 5...
What's the difference?
We look at 5.6 and following to see how those factors are then treated by reference to the facts. And in relation to each of the factors, there is no concrete or certain gain identified. The closest one gets to that is 5.8 through to 5.10 when dealing with the fees. And what this really shows is that far from the fee deterring people moving to work, the fee deters people from paying the fee. In other words, they move to work but don't pay the fee. And that's not sufficient to stop a serious disturbance of the labour market. And then at 5.16, we have the critical conclusions. And this is the passage that has to then be summarised in the foreword and the summary. It is possible that some factors, including the 90% registration fee, could, not would, could have a small effect at the margin. But then could is transmuted by the word will in the next sentence. And I think the answer to the question posed by my Lord Kerr must surely be this. That next sentence must be read with, if you like, brackets after the word will, in the scenario we've envisaged in the preceding sentence. In other words, if the small effect comes into play, then the effect will be slightly to reduce flows relative to what would otherwise be reserved. There is no other way of reconciling those two sentences. That conditional language then flows through into the conclusions in section 5.5, and in particular the wording at the end of 535. Nevertheless, it's plausible to argue the abolition of the WRS could potentially result in a small positive impact on immigration inflows, though it omits the words at the margins. So, very little evidence. There is one final reason for caution, and it is this. When this court in Zawelska was considering the benefits, there were in fact two benefits put before the court. Benefit one was monitoring with a view to more serious condition. Benefit two, which you can see from paragraphs 35 and 36 of Lord Hope's speech. Benefit two was that the effect of the scheme would restrict entitlements to benefits. That was put forward in it and of itself as a separate ground of justification. You see that in paragraph 35, MS page 1530, and paragraph 36, where he's talking about the aims, the twin aims of monitoring and benefits. And that was a twin aim is made plain by the Freedom of Information note in bundle 2.4, tab 74, MS 2617, and in particular paragraph 8 makes it plain that the government announced in February, following a backlash against a proposal simply to let A8 nationals in, that would it put in place transitional arrangements, and insert the words 1, to monitor the number of people from the new member states working in the UK, and then you can insert 2, to restrict access to social assistance by work seekers from their states. Now, if you're with me in relation to the construction of paragraph 5, by the stage that you get to that point of analysis, eliminating benefits liabilities is no longer a relevant consideration because it doesn't operate to address a serious disturbance in the labour market. And it follows from that all of the many passages in the MAC report that analyse the impact on benefits, and there are substantial passages analysing the impact on benefits, are with respect beside the point, because they are not matters that can go into any proportionality assessment conducted by the Secretary of State, if there had been one, and we adopt what my learned friend says, there is no evidence of one, or indeed adopted and applied by this court. The consideration that the scheme will limit entitlements to benefits is wholly irrelevant by the time you get to paragraph 5 of the accession agreement.
And you've got to the end of your time, Mr. Tillman. Thank you.
I hope you forgive me for going, I think, about a minute over. But.
Ladies and lords, I've got quite a lot to get through in my 27 minutes, and for that reason I've copied the note, my reply note, insofar as it replies to what was submitted yesterday. Obviously I haven't been able to do that in relation to what has been submitted today, but I hope that the having a copy of my speaking note will speed things up and also assist the court in not having to note down references. So I start, ladies and lords, with the question of what options were available to the UK in 2009. I hope I can do this relatively quickly because I think that that there has a degree of common ground has emerged. But we say that the discretion accorded under paragraph 5 is a binary one, either continue the measures that the state had in force, if it had any in force, at the 5-year point, or not. Lady Black posed the question, what does these measures mean? Is it a reference back to the very measures that the state had in force at the 5-year point, or is it just a reference to national measures generally? And our answer to that is that it must be the former. And that is supported by looking at paragraph 12, which, as Mr. de la Mare put it, tells you that the system is a ratcheting one. You can increase rights of free movement, but you can't decrease them. That is, of course, subject to paragraph 7, but paragraph 7, first of all, only applies, and I think this is now common ground between us, to those states which have decided to apply Articles 1 to 6, either during years 3 to 5 or during years 6 and 7. But there's another point, and this is quite an important point, why paragraph 7 would not do to address the situation in which the UK found itself in 2009. And that picks up a point that was raised in argument just now by Lord Sales, which is that if one looks at the precondition for the applicability of paragraph 7, not only is it the Commission that must act under paragraph 7, but the conditions on which the Commission can act are that there is an actual or foreseen disturbance in the labour market, seriously threatening the standard of living or level of employment in a given region or occupation, and the measures permissible are only those which can be introduced in order to restore to normal the situation in that region or occupation. Now, that is simply not apt to address an economy-wide problem such as faced the United Kingdom in 2009. It was not facing difficulties in a particular occupation or region. It was facing a country-wide and indeed a worldwide financial crisis. So the options available to the Secretary of State in dealing with the economic situation in 2009 were indeed binary. Either extend the existing measures or relax them, knowing that the MAC's view was that this would exacerbate, albeit by a small amount, an already dire economic situation. Now we say, and we've said it already, that the preconditions for the exercise of the power in paragraph 5 are simply those set out in paragraph 5, namely the existence of serious disturbance in the labour market or threat thereof, and notification of the Commission. But I did accept, in answer to a question that was posed by Lady Hale in argument, that the measures did have to be rationally aimed at addressing in some way the serious labour market disturbance. And we say when you look at the MAC report, the MAC actually addressed this very issue. They look at it at paragraph 3.2 of their report. And they ask that very question. And they say...
Can I ask, do you accept that that flows from EU law? I remember you making the submission that that's
yes.
a matter of Padfield domestic law. But sorry,
yes, I do. On the basis of the authorities that Mr. de la Mare has shown you, that does flow. That does have to be the purpose. But Mr. de la Mare needs to go much further than that, because he needs to show that there is an additional requirement, and the way he put it was a requirement of materiality. And the way he puts it in his written submissions is that the measures have to be able to reduce materially the serious disturbance in the labour market. And we say that cannot be the threshold or requirement, because if one looks at the wording of Article 5 and compares it, for example, to the wording of Article 7, there is no requirement that the measures in question should be capable of restoring to normal the disturbance. That's the wording in Article 7. And no requirement that they should be capable of rectifying the situation. That's the wording used in Article 37, to which Ms. Mountfield drew attention.
Is there a requirement that they should be capable of having an impact?
Well, I'm quite prepared to accept that there is a requirement, an implicit requirement, if you like, that they should be capable of having an impact on the situation in the sense of either reducing the disturbance or preventing it from being exacerbated. And that is the issue that the MAC looked at. They asked the question, will retaining these measures avoid exacerbating the situation? And the answer they gave was yes, by a small amount.
Just in relation to that, sorry to take up part of your
Yes.
time. The MAC also looked at reducing the burden on the social security budget. And Mr. de la Mare says, well, that's not something related to alleviating labour disturbance. Do you accept that?
Well, I accept that alleviating the strain on the social security budget isn't in and of itself related to labour market disturbance, but certainly the social security effects are part of the impact on reducing inflows. So the fact that there is a registration scheme and that people who do not comply with it will not qualify for social assistance is one of the matters which will impact on the extent to which they are disincentivised from coming to the UK.
Yes, thank you.
Now, 2 points were then made by Mr. de la Mare just now in relation to this issue. We say there's nothing on the face of this to indicate that the measures adopted have to pass some particular threshold of efficacy in addressing labour market disturbance. If they did, member states would be, we say, perversely incentivised to adopt measures that offered less freedom of movement. The incentive would be, if there were such a condition, to adopt more stringent or less generous measures. Mr. de la Mare makes 2 points. First of all, he talks about Malta and Cyprus and says that you can draw from the exclusion of Malta and Cyprus from the A8 countries a conclusion about what was intended here. We say you can't draw anything at all from a political decision to extend these transitional provisions only to 8 rather than 10 countries. And the second point he makes is based on paragraph 56 of Lumsden, which is about the quality of evidence. But to pick up a point made by Lady Black in a different context in the course of argument, the fact that you need to have evidence of something doesn't tell you what you need to have evidence of. It doesn't tell you what you need to show with that evidence. And our submission is that the evidence on which we rely here, which is, as you know, the MAC report, does provide evidence of that which needs to be proved, namely that these measures do address the serious labour market disturbance by avoiding the exacerbation of that disturbance by a small amount. Now, on issue 1, our submission is that Vico Plus establishes that if a national measure is covered by one of the transitional provisions, pick up Lord Hodges' point in argument, the words in paragraph 25, covered by, not the same as the words justified. If a national measure is covered by one of the transitional provisions in the Act of Accession, no question of its proportionality in the light of the treaty provisions on free movement can arise. And given that the treaty excludes as a protected interest the bundle of interests that can be grouped under the heading free movement interests, we've sought to address 5 possible objections or ways to answer this argument. The first is Ms. Mountfield's suggestion that by virtue of accession, A8 nationals have the full panoply of EU rights, including free movement rights, until such time as a member state chooses to derogate from these. Now, we say that as a matter of pure chronology, that is simply not correct. So if one looks at the accession treaty, which is in bundle 1.1 at tab 4, and in particular at 597, and in fact one can pick it up actually from Mr. de la Mare's very helpful table as well. The position is as follows. Under the first subparagraph of paragraph 2, member states are required to introduce national measures by way of derogation from Article 1 to 6 from the point of accession for the first 2 years. They're required to do so. So there are no free movement rights during the first 2 years. Then, at the 2-year point, member states have a discretion to continue their national measures until the 5-year point. In a member state which does so, A8 nationals will not, at any point during that period, acquire free movement rights. And again, under paragraph 5, in a member state which chooses to extend protection up to the 7-year point, there will be no point in time. There is no temporal gap, in which an A8 national enjoys free movement rights.
In respect to the first 2 years, won't the rights enjoyed by the new European citizens depend on the extent of the national measures?
Yes, but they will be rights which are enjoyed under national law. They're not free movement rights, and one can see that by looking at Article 1 and taken together with Article 2, because one sees that Article 39 and the first paragraph of 49 shall fully apply only in relation to the freedom of movement, etc., subject to the transitional provisions laid down in paragraphs 2 to 4. And the transitional provision requires the disapplication of the free movement provisions for the first 2 years. So the scheme of this treaty is that while the free movement provisions are disapplied, they don't apply to people, to A8 nationals at all. What does apply are domestic national measures, which may grant a species of free movement right under national law. But at that point, A8 nationals do not have free movement rights. Now, we say it's wrong, therefore, to characterise our submission as one that involves extinguishing or ousting antecedent free movement rights as a worker. Rather, the effect of our submission is to provide that those rights never come into existence during the transitional period. That was one of the conditions of membership on which the A8 states were admitted. Now, the second point is also made by Ms. Mountfield, is that in Vico Plus, no one was suggesting that the national measures in question were disproportionate. Well, they were, and one sees that from both the Advocate General, paragraph 19, and the Court at paragraph 18. The Advocate General and the Court were making clear that that was the reason, or at least it was one of the reasons, why the National Court had referred a question to the ECJ.
But
the question...
Sorry, can I just ask for your assistance on that?
Yes.
Whose rights was it said to be inconsistent with? Are the rights not those of the operating companies rather than the workers themselves?
Yes, but that doesn't matter for these purposes, because it was common ground in Vico Plus that the accession treaty was effective to exclude free movement rights for workers. The question was whether that derogation was broad enough to also exclude the freedom to provide rights to the freedom to provide services applicable to the claimant in that case, which were inextricably bound up with freedom of movement for workers.
But my reason for raising it is, might it not be said that the proportionality exercise contemplated as being potentially relevant in Vico Plus was weighing up the rights of the service companies, not the workers, with the restriction that was being imposed. Sorry, just to finish the question. So that it might be said that in Vico Plus, the court was not confronting the proportionality exercise, which is said we have to confront, which is looking at the potential rights of the workers themselves.
Well, my answer to that is that the reason why I'll put it this way, that the claimant in Vico Plus was in a better position than the workers, because the workers' free movement rights were expressly derogated from in the treaty. The question in Vico Plus was whether the claimant's freedom to provide services was also subject to a derogation because it was inextricably linked with that free movement right? And the answer was yes. So the reason that the court gave for concluding that no proportionality analysis was required under Article 56 and 57 applies a fortiori here. The reason was that freedom to provide services was inextricably linked to the free movement rights of workers, which the treaty contained a derogation from.
Thank you.
So we say Vico Plus is a fortiori on that point. Now, the third point is that it picks up a question from my Lord Sales about whether A8 nationals were citizens at the time of accession. And that raises the question whether, even if the accession treaty excludes as a legally protected interest free movement as a worker, citizenship could itself provide an alternative protected interest which might separately engage the general principles of EU law, including the principle of proportionality. We say precisely that argument was advanced before this court on behalf of Miss Meergar, and it was rejected by Lord Neuberger at paragraph 43. We've given the reference there. What he said essentially was, you need to look at the words of Article 21 of the TFEU. The citizenship right, the right to reside, consequent upon citizenship, is in paragraph 21 made subject to the limitations and conditions laid down in the treaties and in the measures adopted to give them effect. And those included both the Citizens Directive and the 2003 Accession Treaty. And the consequence was that because Miss Meergar had not done 12 months uninterrupted work, she could be validly denied a right of residence in the UK and social assistance. Fourth point was a suggestion that Article 1.3 of the Accession Treaty has the effect that all of EU law, including provisions concerning rights and obligations of the member states, applies. We say, well, there's no doubt that EU law does apply, but as amended or supplemented by the Accession Treaty. So, if, for example, a member state purported exercising a power under the Accession Treaty to interfere with the free movement of A8 nationals as self-employed persons, they would have to justify their action as proportionate under Article 49 of the TFEU. Why? Because there's nothing in the treaty which disapplies that particular right. That interest, if I can put it that way, is protected, notwithstanding the provisions of the Accession Treaty. The reason we say the impugned measure is not subject to proportionality analysis is that the interests it affects are precisely those which the treaty provides are not to be protected, namely free movement interests as workers. The fifth point we make responds to a question raised by Lord Kerr, which is, well, if Vico Plus had really been intending to sweep away proportionality review, it would have done so more clearly. We say that the judgment is indeed clear that no question of proportionality review in the light of the relevant treaty provisions. And I've already answered, I hope, the question, what are the relevant treaty provisions, and does that give rise to a point of distinction? But we say, if it is a point of distinction, it's an a fortiori point. But it is clear, we say, that no question of proportionality review arises if the measure is covered by the relevant derogation. And we also say if substantially the same analysis fell to be undertaken under the guise of a general principle, one would expect the court to have said so, particularly in the light of what it said at paragraph 22. But in any event, it's not a case of sweeping away proportionality review. As I've said, measures adopted under the derogations would be subject to proportionality review if they interfered with an interest protected by or under the treaties as modified. The reason the proportionality review does not apply is because they do not interfere with any interest that is protected. I made reference then following that, and I'm don't have the time, I think, to dwell on it, to a paragraph or a passage from Advocate General Van Gerven's opinion in Rush Portuguesa, which you have in Authorities Bundle 22, tab 52, MS 1861, which supports that analysis. He says, when one's looking at the proportionality question, proportionality, so far as free movement is concerned, cannot arise, but it can arise in relation to other interests which are not the subject of derogations. Next, there's Valesco. I didn't go to that case, Ms. Mountfield did, and she sought to suggest that that case was a case in which a proportionality analysis had been conducted. Yes, it had, but the facts of that case were very different. The reason that the court had to undertake a proportionality analysis in that case was that the relevant transitional provision allowed member states to maintain in force quantitative restrictions which had applied prior to accession. But prior to accession, there was already in force an EU regime which governed quantitative restrictions from third countries. And so the proportionality analysis was simply asking, under that prior legislative regime, whether the restrictions in place at the time of accession were proportionate. And the key, we say, to the case is to understand that under the EU law applicable then, quantitative limits had to be proportionate. And we say that there's no relevant analogy with our case, because there would only be a relevant analogy if, for example, there was, at the time of accession, already a form of proportionality control on free movement restrictions imposed on nationals of third countries, which there was not. Now, the next authority referred to by Ms. Mountfield was Zalewska, and she sought to argue from, this is on page 6 of my note, from paragraph 27 of Lord Hope's speech in that case, that once an A8 national is admitted to the labour market of a member state, free movement rights apply. But one can see the answer to that from the same paragraph of Lord Hope's speech, and I'll just invite you to look at that. It's paragraph 27, and it is final sentence. The reference to Polish nationals admitted to the labour market of a present member state in the third subparagraph of paragraph 2 is a reference to Polish nationals who have been admitted to it under the national measures regulating access. And that point is taken further in Profeta, we've given the reference, unless and until registered in accordance with the WRS, an A8 national has not been admitted to the UK labour market and so does not enjoy free movement rights. We've made a number of points, which you can see on page 6, in relation to A1, P1 and Article 14. Essentially, the points we make are HC and Nuasli, especially HC, shows that differences in eligibility for benefits between persons who have different statuses under EU law do not in general offend Article 14. And that answer can't be avoided by saying that the reasoning only applies when comparing a third country national who has no status at all under EU law with a full EU national, because HC itself was comparing two statuses conferred by EU law, the status, you recall, of Zambrano carer versus the status of a full EU citizen. As to Ponomariov, that case is different as the Strasbourg Court itself said at paragraph 55, because the approach which is applied in the context of benefits does not apply in the context of education, education being a right specifically enumerated in the Convention. Now, on issue 2, and I don't have much time on issue 2, but I don't think I need it. There are 2 errors of approach which we have identified. The first is the upper tribunal judge's failure to appreciate that a member state is entitled to decide to achieve a low level of protection. Once you accept that a member state is entitled to make that decision, that was the objective that the measure sought to achieve. That being so, Judge Ward was wrong in principle to conclude that the measure in this case was inappropriate to achieve the effect sought. The second error was wrongly taking into account the limits on free movement rights, which we say don't apply. And one can make that point again by reference to Zalewska. We say this, and if one looks back at the way that the proportionality analysis in Zalewska unfolded, the reason why there was a dispute or a debate between the majority and the minority in Zalewska was because the minority held that the aim in Zalewska, namely monitoring, could have been achieved by less intrusive means, namely by simply relying on the criminal prohibitions applicable to employers who employed people that were not authorized or not registered. So Zalewska is a less intrusive means. The question of proportionality that was at issue in Zalewska was focused very narrowly on the question of less intrusive means. Now, of course, we know that the majority held that it passed the proportionality test on that point. But if one just looks back to Zalewska, and in particular to paragraph 32
You're
of Lord
just about
Hopes,
out of time, Mr. Chairman.
Yes, can I just make this one final point, my lady,
Of course you may.
in relation to paragraph 32 of Lord Hope's judgment. Last sentence, paragraph 32. This was a case where, just as Ms. Mountfield and Mr. de la Mare have done, the applicant in Zalewska sought to rely on cases which are dealing with national measures derogating from free movement rights. Now, here is Lord Hope's answer to that. I do not find these decisions helpful in the present case, where the rights conferred directly on workers by the treaty and Council Regulation 1612/68 have been suspended by way of derogation in favour of national measures applied by member states. So even Lord Hope, even the House of Lords in Zalewska, which of course under issue 1 we are saying should not be followed, even there, the proportionality analysis that fell to be applied in their view was one which did not apply the same analysis as the case law dealing with national measures derogating from fundamental freedoms. And yet, when you look at Upper Tribunal Judge Ward, and in particular paragraph 117 of his opinion, that is precisely what he relies on. He relies not on a less intrusive means analysis. Indeed, he expressly disavows any less intrusive means analysis. He relies entirely on proportionality stricto sensu, bringing into account as his basis for finding the measure disproportionate, the effect of that measure on the free movement rights, which have been the subject of an express derogation. We say that was a clear error of approach in his proportionality analysis. I haven't had time to answer anything in relation to issue 3 or issue 4, but I rely on the submissions that I've made originally on that, both in my case and orally.
And yesterday, yes. Thank you all very much indeed. Well, you've given us plenty to think about, all of you, so we will now go away and do so. Court's adjourned.